Hi, everybody. Josh Denbeaux, consumer attorney. Today, I want to talk about two topics, really one topic: standing in a foreclosure case and out-of-state fraudulent mortgage modification companies that sell you mortgage audits, forensic loan audits, and other nonsense. And they're very related. First, the out-of-state mortgage loan modification companies. They're lying to you. They're stealing from you. If you paid them a penny, please call me. I'll sue their pants off under the Consumer Fraud Act. Nothing out of your pocket. I hate these people. They are ripping off folks that I could otherwise help. They are costing people's homes, and they're presenting nonsense ideas for defense of a foreclosure case. If you bought a forensic loan audit, it's about 13 pages, costs $12 to run off the system. And you bought it for $1,200 or $3,000 or $800 or whatever you paid, whether you paid $1 or not, it's a fraud. But I'll tell you what it said. I don't need to see yours to tell you what it said. It goes through this long list of check boxes and explanations. Yes, we looked at the how much you put down on the payment. We looked at the interest rate. We went through Edgar and we found the loan and this loan and the other. And oh my God, the person suing you in foreclosure doesn't own your house. You've got a standing argument. All right, you don't have a standing argument, but it sounds like you do. And it gives you an argument that you can look on the internet and see, wait a second, all these people are making standing arguments. There's got to be something there. No. If you're going to rely on a standing argument, and I have people coming to me saying I lost my house, but the bank took my house and they didn't own my house. I'm like, oh my God, you must have hired one of these stupid companies. I can't help them. If they came to me a year ago, I could have helped them. If I hadn't listened to these idiots, I could have helped them. Look, the standing argument doesn't work. And there's a couple reasons why it doesn't work. And it's a little wonky, but if you're watching this far, you won't wonk, all right? Number one, the Truth in Lending Act provides, and that's the statute that governs the origination of these finance debt, among other things. The Truth in Lending Act provides that a mortgage servicer acting on behalf of a mortgage loan owner can foreclose to enforce the underlying obligation secured by the mortgage owned by its parent company or the company it's working for to service the debt. What that means is that if you're dealing with a servicer who's a plaintiff, and you go and you spend a dozen hours looking through Edgar and the SEC filings, and you look at this servicer and you see all the lists of loans they own, which is probably zero, and your loan isn't there, you haven't proven that you're right, that this bank should, this foreclosure plaintiff shouldn't be allowed to sue you. You've proven nothing, because the mortgage servicer doesn't own your loan. And they're not suing you in foreclosure because they own your loan. They're suing you in your foreclosure because they're employed by someone who owns the loan. If you want to get super technical, and there's no problem with doing that, what should happen, and it doesn't always happen, what should happen is the note should be in the possession of the servicer, either by negotiation, which means the owner signed the back and gave it to the servicer, or transfer, which means the owner gave it to the servicer without signing anything or signed it in blank. Usually happens. If it doesn't happen, it's still not a great defense, because the bank and the servicer are like, oh yeah, okay, well, they have it now. The best you're going to get is a couple extra months of time. And that's after, many hours spent fighting over something that can be basically a non-issue. The second is, what should happen is there should be an assignment of mortgage from the owner of the loan into the servicer, and that doesn't always happen. And the Truth in Lending Act doesn't require it. I think that the rules of court in New Jersey do require it, because the rules of court in New Jersey require the foreclosure plaintiff to include in the foreclosure complaint an assignment of mortgage referencing the entire chain of title. To my mind, the chain of title must include the servicer, because if the servicer plaintiff does in fact succeed at the foreclosure sale and take the property back, they become the owner. And if they become the owner, there's sort of a gap there between the mortgage loan owner and now the owner of the house that's not explained unless there's an assignment of mortgage from the mortgage loan owner to the servicer so they can foreclose, but they don't always do that. thus far, even since 2008, the courts have declined to address this point in a clear fashion. And I don't want to get into why. The point is they haven't addressed it. And the biggest problem we have is the failure to clearly address it supports, or it appears to support, the stupid argument that standing exists as a defense of any value on its own in foreclosure litigation in New Jersey. I'm sorry for getting so deep in the weeds and so wonky. All right, there's just a lot of nonsense out there. Okay, this may not be what everybody wants to hear when they listen to an attorney who knows what they're talking about, talk about foreclosure in New Jersey, but it's how it works. Are there defenses to foreclosure? Oh, hell yes, there are. Are there strategies to help people and help people save their homes? Yeah, yes, there's plenty. Does the standing argument ever play a role? Ever play a role? Yes. I'll tell you a story. I had a case, remember the name, but I'm not going to say it, where my client was sued. There wasn't the servicer involved. It was just the mortgage owner who was foreclosing. And it went, and the chain of assignment went from bank A to bank B. Okay. Bank B to bank A to bank B, bank B to bank C, bank D to bank E to bank F, and F was the filing foreclosure. So the problem is there's A to B, B to C, but there wasn't the C to D. There was no assignment in the foreclosure pleading. And that might have just been, an error, a mistake, and what have you. They just forgot to put that in the paragraph. That's a solvable problem, but there just wasn't any evidence that it transferred from C to D. And there was no proof of a signature on the note. So there was a question. Should it have been fatal to the foreclosure pleading? I don't know, because it doesn't answer the question, but it should raise the question. But we're in front of a judge who's like, I've done this enough. Boom, summary judgment for the plaintiff. And I remember going to the appellate division on the case, and we were the last in the day at my request. And so we'll get up there. I'm the appellant. So I go first, and then the bank argues for a period of time, and then there's the reply, and there's supposed to be strict deadlines, timelines in these arguments. You get up and you say, okay, judges, I'd like to reserve 3 minutes for my reply. And I think I said I reserved 2 minutes for the reply. I made my argument on the standing issue and a couple of other issues in the case. The other side came up and just said, hey, I'm a bank. I did this, I paid the taxes, they're arguing this, but the bottom line is I paid. Okay, fine, whatever. It's a pretty credible argument that they did in fact pay the taxes, and that is some evidence that they own the loan, but still we should follow the strict guidelines of the legal requirements. And then I argued, and I didn't get 2 minutes, and I didn't get 3 minutes, I got 45 minutes. And my argument was Article 9 of the UCC, which is, Judge, look, Article 9 applies. Nobody, meaning none of the judges in the appellate division, have issued a decision on Article 9 that clearly explains how Article 9, which governs ownership of mortgages and transfer of mortgages, ought to be interpreted in foreclosure. I'm not going to go through the entire argument because that's too wonky for a video. But the point was, look, under any reasonable interpretation of Article 9, this foreclosure plaintiff can't prove its case without testimony from somebody explaining the transfer between the two missing banks. That was the argument. It went on and on. The judges pressed me. I fought back and forth in a very intellectual argument. And finally, I said, look, guys, it was two male judges up there. I said, guys, look, at this point, I think I'm right. I know I'm right on the law, but am I right on the law? Because you guys get to make the call. But here's my plea. Please make a call. Don't make the call. Call as you see it. I think I'm right. He thinks he's right, my adversary. What we need from the appellate division is the appellate division to make the call. Tell me I'm right. Tell me I'm wrong. Tell us we're both wrong. Come up with a different explanation. Just address the issue in your appeal, please, because at this point, I'm getting so tired of making this argument with no responsive, no corresponding opinion on it that, I'd almost willing to settle for a couple of beers across a high top. We just talk it out and someone tell me if I'm right. And the judge said, well, we're not going to do that because we're very serious and we're black robes, but we will address your argument in the decision. They didn't. And so the day after I got the decision, I mean, the day I opened, I'm like, all right, cool. All right, I didn't win. That's not good, but let me see. Wait, it's Article 9. What's going on? Are you kidding me? So I immediately filed a motion for reconsideration. My motion for reconsideration was like half a page. It was every other argument in this case, of which there were many, is waived. We're not looking to appeal those. We just want a decision on Article 9. That's it. Win, lose, or draw, we want you to address Article 9. And the appellate division came back with a one word. They beat me. I had a half a page. They had one word decision that said denied. And so I took a petition for certification to the New Jersey Supreme Court. And I laid out my arguments and I said to the Supreme Court in like, 4 pages or something, look, the courts need to make a call. This court doesn't need to make the call. You don't have an underlying split because the courts below won't address the issue. So don't keep jurisdiction, remand to the appellate division to render a decision on this issue. Denied. So look, that's my war story. Am I eventually going to get a good decision on Article 9? Yes, because I'm right. Is it going to happen this year? Maybe, because brand new situation we're all in. When the foreclosures restart, God knows when that's going to be. I think it's the third quarter of this year, but could be a lot earlier. We're going to see a lot of litigation, a lot of issues, a lot of problems that we're all going to have to address, and they have to be addressed well. So to wrap everything up, if you're dealing with an out-of-state modification attorney or foreclosure, forensic fraud examiner, oh God, I want to sue them. But other than that, if you're dealing with those jerks, you're being told that you have a standing argument. Watch the video. You don't. And you shouldn't be talking to those jerks anyway. All right. So that's me. Happy New Year. Hopefully 2021 isn't as terrible as 2020, right? All right. Later.